witnesses. Nicholas J. Johnson is a law professor at Fordham. He's held that position since 1993. He's published articles on the subject, firearms regulations and environmental law. Prior to Fordham, he practiced law as an associate with Morgan, Lewis, and Bokius, served as vice president and co-owner of Westar Environmental Corporation, and was of counsel for Kirkpatrick and Lockhart. He taught at 2 colleges as a professor of legal studies. He's the author of 2 books on gun ownership. You, Mr. Johnson, welcome. You want to activate your mic? Thank you.
Does it work? Thanks for inviting me. First, I should say is, sitting through the last 2 pieces of testimony, I'll just affirm the instinct that when one listens to the victims of events like this, the impulse is to basically give them anything they want, and I understand that impulse. And I guess what I would say to people who support the bill, which I have critiqued here, that mine is a counsel of despair, unfortunately. My testimony is drawn from an extensive analysis of this question that I published in 2009. My core point here is that the classifications established by Senate 150 are unsustainable under the lowest level of constitutional review, that they fail even to meet the rudimentary rational basis requirements. To sustain the category of guns that the bill claims are exceptional, they must be banned. We must compare that category to the baseline of guns that are deemed unexceptional, many of which are included in the bill. The characteristics that define the prohibited class are all objectively measurable. And by those objective measures, the classification, I think, is unsustainable. And I've detailed this in Appendix A, which includes the article that I mentioned. The primary characteristic that drives the prohibited category is multi-shot capability. The AR-15, which we've talked about in detail, with its common 30-round magazine, will fire 30 22 caliber, typically 55 grain projectiles, one with each pull of the trigger. Now compare guns that are in the non-prohibited class. Take the common repeating shotgun, either pump or semi-automatic. Hundreds of guns of this type are on the bill's list of prohibited firearms. There are tens of millions of guns of this type in the civilian inventory. In 12-gauge configuration with a 3-inch double-aught buckshot load, any of these guns will fire 15, 33 caliber, typically 60 grain projectiles with a single pull of the trigger. There are a variety of other loadings that will push this calculation upward or downward, but this example makes the point. Additionally, this broad category of repeating shotguns can be continuously reloaded without disabling the gun. That's an attribute that the prohibited class does not exhibit. So the downtime while the shooter changes magazines that has been offered as a justification for the bill's 10-round magazine limit is actually circumvented by this class of shotguns that are on the non-prohibited list. Another claim that supposedly distinguishes the prohibited class of guns is that they are equipped with pistol grips or barrel shrouds, and those things, it is claimed, contribute to unaimed spray firing or firing a cloud of projectiles without aiming. This actually better describes shotgun technology. The shotgun actually does fire a cloud of projectiles that spreads as it moves downrange. Now, these basic points are confirmed by the United States Army assessment of whether the shotgun in battle is consistent with the laws of war. A version of this analysis appears in a 1997 article published in the Army Lawyer. Some excerpts I've included in my testimony. The Army assessment relies centrally on an early analysis by Brigadier General Samuel T. Ansel, whose evaluation continues to form the position of the United States as to the legality of the shotgun in combat. General Ansel's critique was prepared actually in response to a formal complaint by the German government in World War I, charging that the Model 1897 pump shotgun, then in use by U.S. troops, was so destructive that it violated the laws of war. General Ansel's response was this: the shotgun finds its class or analogy as to purpose and effect in many modern weapons. The dispersion of the shotgun pellets is adapted to the necessary purpose of putting out of action one or more of the charging enemy with each shot of the gun. And in this respect, it is exactly analogous to shrapnel shells or a machine gun discharging a spray of bullets. The 1997 assessment goes on to describe a British analysis of the combat shotgun, which reports that to a range of 30 yards, the probability of hitting a man-sized target with a shotgun was superior to all other weapons. On this measure, it was superior to the assault rifle, and this is the assault rifle as technically described, that is fully automatic, firing an intermediate cartridge, and superior to the submachine gun, firing a 5-round burst. When gauged against these objectively measurable characteristics, the rhetoric that defines the prohibited class in Senate 150 not only inaccurately describes the class, but more accurately describes guns that Senate 150 classifies as less dangerous and places on a companion list of good guns. That renders the bill, I'm afraid, incoherent, and that renders the bill unable to pass rudimentary rational basis analysis. My detailed testimony goes in far more depth with regard to other characteristics of this type. My overall assessment here is this. Guns are dangerous. All of them are dangerous. As a class, they are exceptionally deadly, particularly when deployed against unarmed and defenseless people. And on that score, I fear that the conversation we've been having about this particular type of gun is a distraction from the broader issues.
Thank you.